joined us so far. So I'd like to first just welcome everyone to this event about justice for race and gender persecution in the context of Colombia's conflict. My name is Kirby, and I'm the advocacy director at MADRE, which is an international feminist human rights and humanitarian organization. I'll remind people of this, but please know that we have interpretation, which you can find by clicking on the globe icon at the bottom of the Zoom screen and choosing either English or Spanish. And it's good to choose a channel so that you don't end up listening to two voices at the same time. Tenemos interpretación hoy, solo necesitan hacer clic en el icono del globo en la parte inferior de la pantalla de Zoom. Es importante escoger un canal para no tener que oír dos voces al mismo tiempo. And just for all of our panelists, because we have interpretation, that means that we should speak slowly and clearly as much as possible. And before we start, I did just want to acknowledge that the context that this panel is happening as a national strike is unfolding today in Colombia in response to human rights violations happening under the Duque administration, and at a time when Colombia has been seeing massive civil society uprising in the face of extreme state brutality. People are taking a stand against militarization and inequality, and among various demands, they have been calling on the government to implement the peace accord, which is an accord that includes groundbreaking gender and racial justice provisions, and also to address the conditions that have given way to conflict. Simultaneously, there is a very important transitional justice process happening, which has the potential to impact the lives of innumerable conflict victims in Colombia and set precedent for the world. And just by way of brief background for this panel, during Colombia's decades-long conflict, which in some communities is actually still ongoing in many ways, gender-based violence has been widespread and routinely used as punishment against those who deviated from social norms. Black and Indigenous women and girls were especially targeted, as were LGBTIQ and non-binary and gender non-conforming people. And all of these were forms of gender and racial persecution and are also similar to crimes that have happened in conflict throughout the globe across time. And yet no tribunal has ever litigated a successful case of gender persecution. And so today we hope to explore this question of how to achieve accountability for racial and gender-based persecution in Colombia's transitional justice system and what that could mean internationally. I'm really thrilled to introduce our panelists. We have three people. Lisa Davis is Senior Legal Advisor at MADRE, and she's also Associate Professor of Law and Co-Director of the Human Rights and Gender Justice Clinic at CUNY School of Law, and has written extensively on international human rights and gender issues, including women's rights and LGBTIQ rights, with a focus on peace building and security in conflict and disaster settings. Charo Mina Rojas is an Afro-Colombian human rights leader and is part of Proceso de Comunidades Negras, or Black Communities Process, PCN. She played a key role in securing the ethnic chapter and gender provisions in Colombia's peace process, in its peace accord, and served on the Gender Committee of the Ethnic Commission, and is currently a member of the high-level body for ethnic peoples. Rene Uruena is an associate professor and director of research at the University of Los Andes School of Law in Colombia. He's a 3 times expert witness before the Inter-American Court of Human Rights and served as an advisor of the selection committee of the Special Jurisdiction for Peace, which is a component of the transitional justice system in Colombia that we'll be talking about throughout this event. So I'll interview our panelists and then we'll open up for questions from the audience. And if you're just joining us, we have translation. And again, you just have to click on the icon at the bottom of the screen. So first, I wanted to turn to Lisa and just ask you if you could start us off by telling us a little bit about the crime of persecution, the international crime. What is it exactly? And why do you think it could help provide redress to groups who experience discrimination?
Sure. Well, thanks, Kirby, and thanks for that introduction. I think that persecution, or the charge of persecution, is one of the best, one of the greatest tools that we have in terms of calling for accountability under international criminal law, under crimes against humanity as a crime, persecution as a crime against humanity. And it's one of our greatest tools to raise visibility around violence that's been enacted by the intent to discriminate. So here I'm talking about persecution in the form of racial persecution or ethnic persecution or gender persecution. And we need to recognize persecution when it appears, when it occurs, because this is the way that we can get to the underlying reasons of why violence happens in conflict. So persecution itself is just a two-part test. You need the crime, something that's already been recognized as a crime under law or under international law. For example, rape, torture, or murder. And then you need the discriminatory reason why it happened. You need a protected class. And under international law, we recognize different classes such as race, ethnicity, and gender. So that's basically what persecution is in its written legal form. The problem is that persecution isn't really a crime that's applied very often in international or conflict contexts. In fact, gender persecution has never been applied in a tribunal or in the International Criminal Court ever in its history since the inception of the concept of gender persecution. And that's troubling. That means we really don't understand what gender persecution is. And if we don't understand what it is, we can't hold it accountable. So we have to think about what does it mean when we say that gender persecution takes place? And really what we're talking about is that underlying discrimination based on someone's gender or gender expression that they perform that's punished through a crime. So it's looking at the reason why rape happens, why torture happens, why murder happens. And if you can get to that underlying discrimination, you can start to chip away at those drivers of conflict that cause conflict. And we need to have more emphasis and more work done on this issue if we're really going to be able to address it holistically. And the same goes for racial and ethnic persecution as well. It is looking at why those drivers of conflict, why that discrimination that happens in violence and in conflict, why it happens, and how we can capture it in our charging so that it can be adequately addressed and we can start looking at what the systemic problems or root causes of such violence is.
Thank you for that explanation. I'm wondering if you could expound on that and give us some examples of what persecution looks like in conflict. We know that persecution, including based on gender, has been documented in wars, at least since World War II. So why have we missed addressing it for so long?
Yeah, I mean, that's a great question. I mean, when we think of persecution, when we think of gender persecution, for example, what's the greatest example in history that comes to mind? Everybody knows it. It's World War II. It's the persecution of homosexuals during World War II by the Nazis. It was never quite addressed, but it was raised as an issue. So that kind of started the ball rolling in terms of the evolution of the idea of persecution through law. And since the 1990s now, we've had several forms of persecution that's been recognized, gender, racial, ethnic, but very selectively has it been prosecuted, and again, never on gender. To give a more contemporary example, the best example I can think of is ISIS crimes. So here you have perpetrators who were committing crimes based on race, ethnicity, and gender at different times and in different ways. So for example, there are documented cases of women doctors who took off their gloves to perform medical procedures and were tortured for it. Tortured because they were out of dress code compliance for taking off their gloves. There's a documented case of a woman who lifted her hijab to drink water who was beaten for it. There are documented cases that we're all familiar with of men being thrown from buildings for being accused of or perceived as gay. Now, some of these men probably were gay, but we also have documented cases of youth being killed for the same reasons because they had, they were wearing skinny jeans and hair gel and were conflated with this idea of what it might mean to be a homosexual. But all of it is examples of the way they dressed, the way they behaved, the roles they played. This includes women who were killed because they had served as politicians, jobs not deemed appropriate for women. So the way you act, the way you dress, the kind of job you have, your performance, your expression, all of these things, all of these ways that we live as people are regulated through rape or torture or murder or other crimes. These are all examples of gender persecution. And they intersect when it comes to racial or ethnic persecution, like the vast amounts of sexual slavery saw of Iraqi women, and majority being of Yazidi women, but not only Yazidi women. We start to see these interplays, these interconnectivity between different forms of persecution that intersect. And we need to understand them. We need to understand them because what's clear in the ISIS case, for example, is that we're going to get the murder, that rape, that torture. We're going to get recognition. We are getting recognition for those crimes, but we're not capturing the why these crimes happened. And without capturing why these crimes happened, we really don't get the whole picture. And if we can't get the whole picture, we're never going to be able to see holistic redress or healing in communities or accountability, even if it's alternative forms of accountability like restorative justice. We're not going to be able to see any of these things. And ultimately, we're not going to be able to break the cycle of violence if we don't get that accurate picture of why crimes took place. And it's not just Iraq. We see this happening in Mali. We see this happening in Colombia, the regulation of dress, the regulation of gender, stereotypes and discriminatory attitudes placed on Afro-Colombian and Indigenous peoples and regulation of their behavior as well. We see this in conflicts across the world, but we're not capturing it in our transitional justice processes. And that's a problem, because that disintegrates our chances of building sustainable peace.
Thanks for that. Building off of that, what would be your advice to the international community regarding how we can deepen a gender analysis lens to include persecution when it happens?
Well, I think that we've come a long way in the international community in terms of recognizing some forms of gender violence. Specifically, I'm really talking about sexual violence and sexual slavery and various forms and rape and other forms of sexual violence. And that's good. It's good that we've had that codified. But we need to also apply gender-based persecution. It's in the Rome Statute, which governs the International Criminal Court. It's there. It's been recognized for over 20 years. It just needs to be applied. And it's appalling that it's just never been applied in any context. We do have one case that's working its way through the ICC right now, the Hassan case, and there are charges on gender persecution that have been charged there. So we'll see how that case plays out. But other than that, there's never been a successful case. And without that kind of recognition, we really can't get to the roots of what causes violence. So my recommendation would be that we need to infuse this into our lens in accountability. whether it's traditional or transitional types of prosecution or punishments, or restorative justice reconciliation processes. All justice begins with the recognition of what is a crime to begin with. And we need to recognize the discrimination behind the violence if we're going to be able to get to holistic accountability.
Thanks very much for that in-depth explanation, Lisa. I'd like to actually turn now to Charo Rojas, who again is with Proceso de Comunidades Negras, or Black Communities Process in Colombia. And Charo, I wanted to ask you, we heard a lot from Lisa about how persecution happens in conflict and in general. And I'm wondering if you could share with us what persecution crimes have looked like against Afro-descendants and Afro-descendant women in Colombia's context.
Thank you, Kirby, and thank you everyone that is connected, that is with us in this conversation. I'm gonna try to be concise, but I want first of all to put this question in a little bit of context, because in one hand, there are crimes committed by armed groups, army, guerrilla, paramilitares, criminal gangs linked to narco traffic. But then the other, there are those committed by the state directly or by omission of its responsibilities. In any case, the perpetration of these crimes had to be seen and understood in the context of historical, racial, and gender ethnic discrimination in Colombia. That creates a situation of enough vulnerability and fragile institutional context that promotes and allows the perpetration of those crimes to happen in the disproportionate dimensions that have impacted Black and Afro-descendant women and people, and to whom these are directed. I'm talking about the tremendous social gaps, social and economic disparities persistent in Black Afro-descendant communities, the total absence of state guarantees for recognition, respect and promotion of our rights, despite the many, many laws and normativity intended to fulfill that purpose. I'm talking about the rampant impunity, the indifference and blind eye from the state and institutions regarding crimes against Black Afro-descendant people and women, the imposition of economic policies, the mega development projects and infrastructure, denying and violating rights of participation, prior consultation and consent, territorial and cultural and environmental rights, health, reproductive rights, a context that the Colombian Constitution Court declared in 2005 like a state of unconstitutional matters that for us are nothing else but the results of systematic structural racism and patriarchy. So then I think we need to talk about the gender, but also the ethnic and racial persecution crimes against Afro-descendant women in Colombia. And those comes in the forms of physical, emotional, economic, environmental, cultural, institutional violence. So it goes from the brutalization of the women's and girls' bodies, the rape, the mutilation, dismembering, torture, forced prostitution, obstetric violence, to disappearances, to kidnapping, to forced recruitment, human trafficking, forced displacement. But I think it also things like the territorial and cultural dispossession, the laws of the children, the economic loss by that dispossession, and all the cultural impacts that this cause. All crimes, the criminalization, for instance, of social leaders that we have been suffering for some time now, all crimes that subject Black Afro-descendant women to constant threat, terror, suffering, health and environment and emotional harm, severe deprivation, overall rampant violations of the most of her rights, sometimes all at once, or many at once. So for us, these crimes are committed because as ethnic people, as authorities, as women part of those ethnic authorities and groups, and because the specific locations and territories and areas where we are located, territories under particular economic or political interest, where we become seen as an impediment, as a problem, because we have particular role defending our individual and collective rights, defending the territories, the environment, protesting and confronting plunder, exploitation of ancestral territories, where the government privilege economic development over human beings that are not seen as such, and over human rights. Because of all that, and the demands that we have on reproductive rights that are considered danger to moral and patriarchal stability, and so on. So between all that is the fact also that we are statistically underrepresented. It's very difficult to trace how many Afro-descendant women has been raped, killed, how many disappeared or dispossessed, to just mention piece of the problem. So all of these that I have mentioned for us are inhuman acts of persecution that are based on gender, racial, political, and economic grounds. This is kind of the spectrum for us.
Great. Thank you for providing that context, that broader context that Afro-Colombian women and girls and their communities are facing, including the social and economic disparities and the lack of respect for collective rights and individual rights. I'm wondering if you could talk about what PCN has been doing to document and raise visibility about crimes committed on the basis of race and gender against Afro-Colombian women.
Well, mostly since 2013, we have a team of women that have been producing reports and that provide some data, but mostly fundamentally analysis on the complexities of violence against Afro-descendant women as forms of violation of individual and collective rights, where gender, race, class issues, sexuality, ethnicity, geographical location, economical or political situation intersect with development, economic policies, military occupation, and different forms. So we have been producing these reports. We had one in 2015, 2018, and the last one was in 2019. We have been trying to document cases related to the conflict, but also I mean, something that has been really, really difficult since most of the victims still live in this kind of war zones, surrounded by the perpetrators in regions completely marginalized with no state presence and total impunity. But during the 2018, we managed to collect data from, document around 100 cases of different types of violence, and we typified them, and those are in the third report that we produced in 2019. We are working on structuring the gender-based violence observatory as a place to share statistics and information in all this analysis with the community in general. This year, we are committed to continue documenting. We have been producing monthly human rights reports, and we just launched the compilation of the first semester. We have been working on structuring self-care and self-protection systems with a anti-racial and ethnic gender perspective. And now we are also committed to do 2 community hearings on gender and race-based violence against Afro-descendant women in alliance with precisely with Madre, we expect to have one of those hearings in December and another in next year. We have been producing reports to different UN and doing advocacy for different UN bodies like CEDAW and CERT, the UN Security Council. We have presented UPR reports, for instance. So this is all in terms of keeping visibility and doing some advocacy and raising awareness on the situation, but also having some impact that comes back in the form of some specific actions to be attending the situation. And PCN is also representing Afro-descendant victims in 2 of the cases with the special jurisdiction peace process, with HEC. So it's kind of overall some of the things that we are focused on.
Great. Thank you so much for sharing that about just the incredible organizing and movement building and advocacy that you all have been doing on these issues for years. I just want to really quickly remind anyone who's joined who's new that we have translation. You just have to click on the icon at the bottom of the screen and choose English or Spanish. Tenemos interpretación hoy, solo necesitan hacer clic en el icono del globo en la parte inferior de la pantalla de Zoom. And then, Charu, I had one more question, which was speaking about the special jurisdiction for peace. Why do you feel that it would be important for Colombia's special jurisdiction for peace to pursue charges of racial, ethnic, and gender persecution? And for people who don't know, the special jurisdiction for peace, or it's called HEC for its Spanish acronym, is a component of Colombia's transitional justice process.
Let me see if I have my microphone on. Yes, I do. Well, all these crimes that I have mentioned, these human rights violations against Afro-descendant women and Black people, have been systematic. And basically our dignity and humanity as ethnic group, as Black Afro-descendant women, has been severely attacked consistently for decades. Our rights as persons, as women, as ethnic people have been severely deprived. So we have insisted that in order to achieve real justice and find venues for reparation, but most importantly, to ensure no repetition for Black Afro-descendant people and women, there is a need to examine and expose the root cause of conflict to find not only the obvious perpetrators, those that directly committed the crimes and the acts, but also the minds behind the behind the scene responsible for the numbers of crimes and human rights violations committed against our people. So to address that persecution allows to deepen into the structural issues and patterns linked to armed conflict and that impact us. So for us, it's some way of accountability because it deepens and goes beyond just the obvious and bring us opportunities to actually go to the roots, which is something that we are very interested on deepen into it, and as part of the reports that we have been producing.
Well, thank you so much. On that note, then I'm going to turn to our colleague Rene Uruena and ask if you could briefly provide an overview of how the special jurisdiction for peace works in terms of the cases that it takes up and the types of cases that it's currently looking at, and whether or not any of those cases directly address racist or misogynist drivers of the conflict.
Yeah, so thanks Kirby, and thank you everyone for being here virtually and for the invitation. Yeah, so as you mentioned before, the Special Jurisdiction for Peace is the War Crimes Tribunal created by the peace agreement, in 2016 peace agreement between the FARC and the government. And basically it is a national court, so it's not an international tribunal, it is a national court, and that national court, applying a national law by domestic judges, tries to deal with atrocities committed during the armed conflict, not only by the FARC, but by all parties of the conflict that Charo explained before. So not only the FARC, but also the military, private parties, if they present themselves voluntarily, so on and so forth. So basically that's, but then two things are worth mentioning about the Special Jurisdiction for Peace. The first one is the fact that despite the fact that it is a specialized jurisdiction, it is still part of the overall judicial system of Colombia, meaning that it also has to apply, which is a very rich set of precedents and case law developed by the Colombian Constitutional Court. And this, for our purposes, is very, very important because the Colombian Constitutional Court has developed very important cases, has decided cases and developed very important precedent in terms of both racial and ethnic discrimination and discrimination on the basis of gender. So that means that the Special Jurisdiction for Peace is not building on a vacuum. Rather, it has to apply constitutionally. It has to apply all these precedents. So that's one thing. And then the other thing is that the court, the Special Jurisdiction for Peace, this court has a very generous system for victims to participate and submit reports and information to the court. So there is a very low threshold in terms of standing. Of course, not as victims, so not everyone is recognized as a victim, but the threshold for presenting information, also in terms of amici curiae or also reports and civil society organizations, is very, very low in terms of most organizations are able to present information. And this is also very important because, as Charo was mentioning before, civil society in Colombia, both groups that protect women's rights and Afro-Colombian groups, they have submitted reports to the Special Jurisdiction for Peace on specific issues. So how does the court work? Basically, the court has decided to work on big cases, let's call them like that. They call them macro cases, but basically it's the cases that deal with important issues in the context of the conflict. So that's the way they classify the cases, not according to victims or complainants, but rather according to situations. And these situations can be of two kinds. One is subjects. So, for instance, kidnapping. For instance, these so-called false positives of these extrajudicial executions. So, these kind of situations dealing with certain subjects, or geographical cases. So, they have a couple of cases that focus on specific areas of Colombia that were stricken particularly hard by the conflict. So they have 7 cases now. I'm not going to go through all of them, but what I'm going to do is perhaps mention 3 that have interesting implications in terms of Afro-Colombians. So, and these cases, interestingly though, it is important to mention that the Special Jurisdiction for Peace today has no specific case on on violence against Afro-Colombians or on violence against women. That's important to mention. What they are doing, though, is that they are tackling violence against Afro-Colombians through the territorial cases, meaning what they have done is they're saying these 3 areas that I'm going to mention in a couple of minutes have been particularly, so they have violence there was particularly intense. And in this area, a lot of Afro-Colombian population was concentrated. So the population there was mostly Afro-Colombian, and therefore we are dealing, the court says, at the same time with the territorial dimension and the ethnic dimension. But they are not dealing with the ethnic dimension in itself, but only through the territory. And that has implications in terms particularly of what Lisa was mentioning before, in terms of dealing with the crime of persecution. Because obviously, when you think about that in those terms, then it's very hard to make the argument of persecution. So three cases, and I'm going to be extremely brief with this. So 3 cases that I think are relevant for the participation of Afro-Colombians and also the victimization of Afro-Colombians during the conflict. So the first case is case 2. It deals with the municipalities of Ricaurte, Tumaco, and Barbacoas. That's in the department of Nariño. And so this case is important. This case is interesting in 2 senses. So the first one is because in this case, interestingly, the territory itself was recognized as a victim. So meaning the ecosystem, the environment in this area, the territory and the relation of the Afro-Colombian communities with the territory itself was recognized as a victim. So this may sound really, really weird, but again, it builds on a set of decisions by both the Colombian Supreme Court and the Colombian Constitutional Court that said both the Amazon and certain readers are actual legal persons, or recognize them as legal persons that can be victims, and in this case, they can be victims of the armed conflict. So that's one thing about that case that's pretty interesting. And also, the other interesting thing about case 2 is that it recognized for the first time, really in the transitional justice process, the Consejo Comunitario de la Altamira y Frontera as a collective victim. So again, this is important because then it recognized that for Afro-Colombians, so there is a process of victimization individually as Afro-Colombians individuals are considered, but also as a collectivity. And then it gave rights of standing, participation, and so on to the collectivity as a whole. So the second case that they have is decided that I think is interesting is case 4. And that case 4, again, it deals with a specific territory. In this case, the territory of Urabá, Antioquia, y Chocó. Obviously, for those Colombians and people who work for in Colombia, they will recognize, obviously, these regions as mainly, particularly Chocó, Afro-Colombian. And then, so this case, of course, the violence in these areas is particularly intense. And here, again, the dimension of the environment for the court is crucially important, and also here the territory was recognized as a victim. And then finally, to close up, we have case number 5 that deals with the area of north of Cauca, and Madre has been doing a lot of work there, and the south of the Valle del Cauca. So these are departments that are in the southern western side of Colombia. And then and these areas, so there the cases have recognized already 47 consejos comunitarios, one of which is one that belongs to, or one that has this several recognized organizations, particularly some that groups a very important group of Afro-Colombians. So as you can see, so there has been developments, but 3 things, and I'm going to close up with this. So first, a lot of things are mixed in these cases. So they deal with Afro-Colombians, but they also deal with the environment. But they are also a vehicle to create new forms of standing for victims of crimes against humanity. So meaning that the dimension, so the specific process of victimization of Afro-Colombians has to be really pushed into these cases by civil society organizations. And I'm sure will tell us much more about that. That's actually the work that Shadow herself is trying to do, her own work, and which is brilliant. But that's part of the challenge there. So these cases, because the analytical unit is the territory, then obviously a lot of things get mixed, and it is very difficult to make such an argument as persecution as what Lisa was mentioning before, because the way the cases are being framed are being understood in terms of the makes it to do that kind of analysis. So that's one thing. So we have the which impact on the participation of afro-colombians. That's the second thing. Yeah. Okay. Great. So that's the second thing. And then just to close up, then what I'm thinking of is I don't know. Can you hear me? It's okay now. Can you hear me? It cut off for a minute, and then is it okay right now?
It's okay now. For like a minute when you were talking about the second thing, it was problematic, but it's better now.
Okay, Rick. No, the second thing that is problematic right now, I was telling you, is the coronavirus. So the problem of COVID, that's really limiting the process of participation. And just to close, and the third thing which is important is that I would think that it is important to ask the special jurisdiction for peace for either a case or a process or a protocol. The special jurisdiction for peace is developing a protocol, but again, that is applicable to both indigenous populations and afro-colombians. Again, they mix these two things, and that's the protocol they're developing. So it would seem interesting, it would seem important to kind of ask the special jurisdiction for a specific way of understanding the process of victimization that also gives account of problems of intersectionality. Case 2 does have an approach of intersectionality, but again, it is mixed with the territorial dimension, and in that context, to make the debate on persecution possible. Because as we are understanding it right now, the debate of motivation and these two elements of the crime of persecution, as Lisa was presenting before, become very, very, these two elements then become very, very difficult to discuss. I hope that my internet was good enough. In any case, I look forward.
Yeah, I think so. And just so that people know, that Consejo Comunitarios, that refers to community councils, if just in case people haven't heard that term, and that's an official unit of self-governance in Afro-descendant territories that Charo could also speak more to. Rene, thank you so much for that really helpful explanation of the HAP. And I'm wondering, you mentioned macro cases and the fact that there is no, gender persecution macro case or ethnic persecution, race and ethnic persecution case. Is that a possibility? And is there still time to do that? Would it actually make a difference?
Yeah, so I think there is a possibility. There are different hurdles. So there are different ways in which this come forward within the case, let's for an existing case, but it is there is also mentioned here a special jurisdiction for here enough to do the interpretation.
I think there's something wrong with the signal, Rene. So can we come back to you if that's okay? Because we're just actually not hearing it, but like the
signal. Exactly. Let's do that. Yeah, okay. I think that's okay.
Okay, and sorry about that. Maybe I could put a similar question to you, Lisa, about sort of what would it look like internationally, or what could be the impacts internationally were there to be a case of gender persecution or race and gender persecution cycling through the HEP system?
I think that right now in Colombia, there's a lot of debate around the pros and cons of asking the HEP to open a sexual and gender-based violence macro case. And, you know, while the benefits of that are obvious, the cons to that would be as if, you know, it wasn't fully carried through properly, if there wasn't enough adequate resources to carry it through, and if that would have some negative ramifications, right? And I think these are the kinds of arguments that we're always thinking about in terms of whether you want to add on, you know, new charges or have a new case go through any transitional justice system. I think the difference with persecution, though, is that you can get to gender and to race and ethnicity without having to necessarily add new crimes, because it's taking the lens and applying it to crimes you already have, because we're looking at that discriminatory intent against a protected class in those cases that you have moving through your judicial system that are rape, torture, or murder, or forced disappearance, etc. So in that way, you can get to the gender discrimination and the ethnic and racial discrimination that underlines, that drives these crimes without necessarily adding crimes. Not to say that we shouldn't be looking at all crimes that happen in Colombia, for sure, but just to speak to some of the conversation that I've heard in the discourse on opening up additional lines, whatever they might be. And the other advantage is that you can get those LGBT crimes too. And you get crimes against women. You get those SGBV crimes, because one of the main problems with SGBV crimes, which, you know, is short for sexual and gender-based violence, is that what we're trying to do with those crimes is really recognize why those crimes happened, why they were based on gender. And you get more of that, why it happened to a woman because she was a woman, why it happened to an LGBT person because they were an LGBT person. You get more of that with persecution. And then you also get that intersectionality. You get that, why did it happen against someone because of their race, because they were Black, because they were Indigenous? And then you can also include, why did it happen against a Black woman? Why did it happen against an Indigenous woman? And you get a different why, a different answer when you ask the question, looking at it from an intersectional analysis too. You get one answer, which we need to answer, about why it happened to Black people or Indigenous people, why crimes happened to them based on race or ethnicity. A different answer based on gender. And then an even more nuanced answer when you look at both of those combined. And without unearthing all of that, we're really not going to have redress. So it would provide a chance to give a more holistic narrative in the historical discourse, greater accountability, greater visibility, and that actually starts to build the foundation for how we're going to build rights for minorities in Colombia, where those gaps have been apparent and need to be fixed.
Thanks for that. Maybe we'll try again and see if we could go back to Rene. And again, just on the question of whether you feel like it may be possible for the HEP to open an ethnic or gender persecution macro case.
All right, so let's give it a try. I don't know what's happening here, but anyways, yeah. So what I was telling you is that so it is possible. There are several procedural obstacles that are not really unsurmountable, and that it should be possible either through a new case. That's one possibility, at the hardest, let's say, but also by creating this debate within some of the existing cases with the limitations that the whole overall framework create. So that's one thing. And the last thing that I think didn't go through when I was speaking before is that we shouldn't forget that the special jurisdiction for peace is but one of the institutions of the system of truth, justice, and non-repetition. The other two being the commission of the Truth Commission and the unit for the search of disappeared people. In particular, the Truth Commission has, of course, a role to play here in terms also not necessarily of creating, let's say, the legal doctrine that would create a crime of, or that would allow a prosecution under the crime of persecution, but really to create the framework of information and also of understanding the context that would feed into the kind of legal analysis that is required for the crime of persecution. So along the lines of what Lisa was saying. So really, we should look at these two institutions in tandem, both the special jurisdiction and the commission.
Well, that links to my last question for you, and I'll just note that after this, we'll ask for questions from the audience, so people can type questions into the chat box. But my question for you, Rene, is if you have any advice for the international community or Colombia's transitional justice actors on what they could or should do to support holding perpetrators of persecution crimes accountable in Colombia's conflict?
Oh, I guess that there are two different actors there. So for the international community, donors and governments is obviously to support and provide a political and economic support to both the Special Jurisdiction for Peace, to the Truth Commission, and to civil society organizations, both in Colombia and outside of Colombia, that are trying to help them fulfill their mandates. So, so it's not news for anyone that the current government of Colombia obviously has very, very big differences with the Special Jurisdiction for Peace, and has systematically tried to undermine its authority, and also with the Truth Commission. So there's no doubt about that. And therefore, what the system, both the institutions and the organizations that appear before the system require of the international community is a cooperation and political support. So that's on the one hand. And then on the other hand, if civil society organizations, obviously they are pretty much they have been in contact with the system. They know how to act within the system, but still there is quite a number of technical and expertise issues that can be tackled. So I think that the combination between international partners, Colombian academia, and Colombian civil society organizations is required there to push, let's say, these last elements of the cases. So I think that would be what I would say about
that. Thank you to all three of you. This has been really, really enlightening, and I want to just encourage everyone to type in questions into the chat box. I'll start with one which is really timely for 1325 week. Someone has asked, Evan Petworth has asked whether how to use the Women, Peace, and Security agenda to uphold accountability for gender-based crimes. So I'm wondering if any of you, either of you, would have.
I would be happy to answer that one. I think that we have 10 very robust UN resolutions under the WPS, Women, Peace, and Security docket that really speak to the various aspects of how to address sexual and gender-based violence and conflict. The most recent resolution to come out, the 2467, gives us for the first time a survivor-centered approach. I think it might actually be the first time the Security Council has ever used the word survivor instead of victim. But what's important about this resolution is that it says that survivors are the experts on the ground. They're the rights holders, and they have a right to participate in peace and transitional justice processes, as well as in the design and implementation, and in peace negotiations, because that voice is necessary to obtain sustainable peace. How do you get a survivor-centered approach implemented? I mean, Colombia had some pretty good components in their peace process to a survivor-centered approach in terms of having participation in, through various mechanisms for, based on, race, ethnicity, and gender. But how we get there is by recognizing that victims, like victims of persecution, have a right to the table. And that category of persecution, again, it gives us a category for victims, and I use that in the legal sense. It gives us a category for rights-based holders that have a right to participate in the design and implementation of peace and transitional justice processes. So.
Thank you. One question is whether or not, and I think this may be good for, I guess you all could volunteer, but whether we're aware of initiatives of representatives of Afro-descendant or Indigenous victims in the macro cases within the HEP that are pushing for recognition of the crime of persecution based on race. Like, is anyone aware of that happening yet?
Well, I can say a little bit about it. We have been trying, because, PCN represents in 3 of these cases. Is representing legally 3 of these cases. But in general, we have been trying to introduce this element of race and racism as part of the considerations that need to be taken when looking at the cases. As Rene explained it, and since this is not my field in terms of legal issues, I wouldn't be able to explain it properly, but one of the key elements, and this is why I initially mentioned this for us, is the need to recognize that there is an important component on the root causes of all the crimes committed against Afro-descendant people and Afro-descendant women that had to do with race, and that had to do with the systemic racism and the structural racism. And now the difficulty, if you will, or the challenge is how to prove this, how to organize the argumentation to show that effectively this is the case. But there is that intention in what we are doing. We are also, I should mention, working on a document, PCN as part of the National Council, Afro-Descendant Council for Peace, the CONPA in Spanish. And we are working on precisely analysis, some document providing more elements to analyze the role that race and racism particularly plays on what has happened to Black people, and especially women during internal armed conflict. So there are attempts to do it, is what I would say.
Great, thank you. Well, we had that last question was from Ana Margarita Gonzalez, and then we have a question from Adriana Torres asking Rene if you think it would be possible to prosecute companies that financed the displacement of vulnerable communities during the conflict.
Yeah, so it is possible. So the private parties before the special jurisdiction for peace had have a long history. So originally the peace agreement would make their presence before the special jurisdiction for peace mandatory. After the whole legal infrastructure of the peace agreement went before the constitutional court said, no, 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 it can't be mandatory, it has to be voluntary. So private parties that appear before the special jurisdiction for peace, they appear if they want to, not because they have to, as was agreed originally. There's a whole discussion on why this is so. The effect of that is obviously that despite the fact that it is possible to prosecute, the structure of incentives has to be such that the punishment that is going to be given by the special jurisdiction for peace is lower than in normal jurisdictions. Otherwise, there is no incentive for private parties to appear before the special jurisdiction for peace. So the answer is yes, it is legally possible, but up to now it has been very unlikely because it is because up to now it is not mandatory, and it won't be mandatory, it is voluntary.
This is more a question if I can, because and Rene, I think that it is not mandatory that they present themselves as responsible. But what about if people present cases? You know, if civil society bring information to a special jurisdiction court, or would that be a way to call them? Because I think that, you know, one big challenge when a civil society present information cases to the HEP is just collect and gather all the information and the evidence to actually bring elements for HEP to find those links of responsibility. So what about that?
So it is so when civil society presents this information, so the special jurisdiction, they have to decide what is the status of these private parties. And if it decides that these private parties are private parties, either so they are not a direct actor conflict, but they remain private parties, so they can't bring them they can't bind them, they can't make them to come before the special jurisdiction for peace. If they decide that they are not private parties, but that they are actual actors, they were actual actors of the conflict, and there are several criteria to decide that, then the whole question of private parties becomes moot, because then they are just one more actor of the conflict. But the threshold is very high, and that's something that a lot of civil society organizations and myself, we have been very critical of that move. But that was the consequence, not of the peace agreement, but of a decision of the Constitutional Court that limited that dimension, and it did it because at the time a lot of both commentators and judges and jurists were saying, look, if the special jurisdiction for peace has so much jurisdiction, it will be able to prosecute not only those that were parties of the conflict, but all 40 million Colombians that had something to do with the conflict directly or indirectly. This, of course, is a weak argument, but that was the logic behind what the Constitutional Court said at the time. So my answer to your question would be yes, so it is possible, but there has to be a link with the conflict, and once you prove that, then the notion of private party obviously disappears. And just to close up with something there is, you know, 30, so because we're in week of resolution 1325, so 1325 is absolutely crucial in the way the Colombian conflict and peace agreement was thought of. So it's really a pivotal, so it's really crucial in the way both things were both understood and the way the peace agreement was designed and implemented. so much so that some analysts say it's too much. So it's too much emphasis on sexual violence, because gender issues are not only sexual violence, but also property, also political participation, so on and so forth. So and the bias within 1325 seems to be only about sexual violence. But there's a whole movement around 1325 in Colombian civil society organizations. There's a coalition that verifies and monitors compliance with 1325 in the context of Colombia. So 1325 is crucial, and it has also been appropriated and used by civil society organizations in Colombia widely. So it's crucially important.
Thank you for that last point. And I think that also ties into what Lisa was saying about the other resolutions that form part of the Women, Peace, and Security agenda, and the way that this call for the recognition of survivors as rights holders is a key way to broaden the understanding of what the Women, Peace, and Security agenda can mean in this context. And actually, speaking about participation, I just wanted to ask one quick thing that I don't know that we touched on, which is some of the participation barriers that people are facing right now. If you could maybe, Charo, just explain that in a little more detail about like what it is that is preventing, for example, the full participation of, a sexual and gender-based violence survivor in Afro-descendant communities, even in the communities that are included in the macro cases. What might be the barriers that they confront?
Well, definitely several barriers. One of the main barriers is the fact that survivors who come, or basically many are located, particularly in these cases, are located in the rural areas, in the areas that are now completely encroached by armed groups, have all these security issues to really be fully engaged and participate in the process. Even with the security measures that HEP has linked to the protection, the National Protection Unit, still there are no enough guarantees, and people don't feel that there are enough guarantees to for their security, being in territories where armed groups are still present and actually threatening constantly, such as the case of Tumaco and all the southern area. So that's one of the major obstacles and problems that people face and survivors face to participate and be fully engaged in the process, even for certification of as victims. The other is, so I would say there are no guarantees really for the process, because we are now in post-conflict, and that's a very significant piece of the situation. There is the full spectrum of I would say this, the methodology used for the process needs adjustments. In one hand, to give it a more ethnic perspective, more a differential treatment, and this is something that is still in discussion, is still adjusting, and meanwhile the hearings are happening and the process is going. So there are no complete defined mechanisms and the methodology to ensure that the participation, the ways that people and women especially need to participate in this process. We are concerned for the fact that many of the, how you call it, Rene, the mobilized that present themselves before HEP, anyway.
Demobilized.
¿Los comparecientes?
Los comparecientes.
No, las víctimas son.
No, los otros.
¿Las víctimas o los victimarios?
Los victimarios.
Ah, no, los comparecientes y otros son las víctimas,
Eso, esa es la palabra. Quiero decir, I was trying to find the word because I couldn't remember. I don't know what that word is in English, but some are not are not anymore there. You know, in the cases, some of the cases that, for instance, PCN has, some of the comparecientes, which is the demobilized people that present themselves before HEP, some are not there anymore. Some have been killed. They moved to some other places because of the lack of guarantees, different situations that had an impact on the process and the participation of the survivors of victims and the hearings and in the process itself. Lack of resources, difficulties on accessing to information. Now with the whole COVID situation, virtuality is an issue because people don't have all the means to be connected, to be, you know, visually participating. So there are all those, some of the main difficulties.
Sorry, great, thank you for that. And just to remind people, if you want to ask questions, please feel free to type into the chat box. And one last question that I have for all of you would be just to kind of circle back to the idea of what, I know each of you touched on this in some ways earlier, but just the idea of what gender persecution crimes looked like, have looked like in Colombia, and how they compare with other parts of the world and other conflicts.
Well, I think certainly my colleagues on this call can speak more to what crimes have looked like in Colombia, but I can talk a little bit about what I know how gender and racial crimes have looked like in Colombia and compared to other parts of the world. So one thing that we see, you know, with gender and racial persecution crimes is that there's a real theme in terms of how they're carried out, and Colombia is certainly no exception. So in Colombia, there's been documented cases of armed actors who have imposed regulations on civilians, from everything from, you know, men not, you know, being able to have certain haircuts and women having to, you know, wear long skirts and long clothing and cover up their bodies, and you know, even gendered crimes where youth have been forced to fight each other. And then, of course, heinous punishments when people step outside of these, you know, oppressively ascribed roles. And then we've also seen it in terms of just stereotypes on women and women's behavior, on queer people, on LGBT people, stereotypes on Black and Indigenous women, in terms of, you know, stereotypes on performance that have been used to underline violence committed against them. And these are very similar to the way that we see gender and racial persecution in other parts of the country, in the world. So, for example, in Mali, in the Hassan case, women and men had dress codes imposed on them in terms of regulation. So, you know, women who didn't wear a hijab correctly. This was also happened in, you know, under ISIS too in Iraq. You know, women who didn't wear a hijab correctly have been tortured or killed. You know, a woman who was caught giving a man a glass of water in public and accidentally touched his hand was tortured for it. It's kind of the same types of oppression that we see in terms of gender regulation. And it can cut both ways on reproductive rights as well. It can cut towards either forced abortions, or it could cut towards forced pregnancies, depending on the conflict of depending on the context of the conflict. And then we also see it intersecting in terms of race and gender as well, like with the persecution of Yazidis in Iraq. But I'm sure our other colleagues could also speak more to these kinds of crimes, these kind of the discrimination underlining these kinds of crimes that happen in Colombia.
Sure. Do either of you want to, Rene or Chato, want to speak to that question?
Well, I will say briefly that for us, we definitely have to be that intersection between gender and race. The stereotyping is one of those central issues, and all the stereotypes that are put on Black Afro-descendant women that intersect as being Black or Afro-descendant, and all the sexual charge that is on Black Afro-descendant women, and then the fact that it's a woman. On that impose a level of restrictions and like impositions on how needs to address herself, how to dress, etc. That there are no, like, by law, but are by the law of the circumstances, if you will. It's hard for me to explain this in English, but I will give you an example of what I'm trying to say. The fact that there was a particular period of time during the presence of the clashes between military, paramilitary, and guerrillas in certain parts of the country, where women was a target because being Black women, and all these sexual stereotyping and impositions on her and her body and what she is. And then, there were so many rules on her in terms of if she will if she will be picked by one of the armed members of one of the armed groups as someone that he liked, and she will attend another person, or even being seen by the other in the other group, that will be enough for her to be tortured or penalized in some way. Most of the time that was death, but death after torture, rape, and other punishments. Women, there was a point where women couldn't stop, like, dressing up, using makeup, combing their hairs nicely, and all those things, so they wouldn't be seen. So they will avoid to be the objects of all this attention, all this ruling, all these impositions. So those, to me, are examples of ways of being persecuted, right? But on the other hand, is all the criminalization of leaders. Being a leader here in Human Rights Defender is really a crime, and both sides. So to me, that has similarities with some other places where when we defend our rights, we become criminalized, and we become a military target, basically. That would be couple of examples.
Yeah, and so just very briefly, so this kind of profiles, they are part of violence as Charo was describing, and but also this also brings to the fore, and I'm going to be a bit critical here, perhaps a bit provocative to see what you guys think, is also part of the problem of the way of mixing the issue of the environment, the territory, and racial violence in this context, because somehow, so as you can see, the Special Jurisdiction for Peace has said, look, in these territories, there has been, when we analyze these territories, we have the environmental problem and we have the afro-Colombian problem in terms of a specific forms of victimization, and through that prism, then we put everything inside the case. But then that, in a way, plays to the idea that, in a way, being an Afro-Colombian means defending the environment. So that these two things are intimately connected, and which is not necessarily true. So there is victimization on one side and on the other, and then one shouldn't think that the environmental issue in terms of the territory recognition of violence against the territory and the territory as a victim is necessarily linked to the ethnic dimension. And why am I saying this? Because this link has a long history in Colombia in terms of the notion of collective property of land. So the notion of collective property of land has been a policy of the Colombian state for quite some time now. But while it has a guaranteed access to land that was before taken from Afro-Colombian communities, at the same time, others are critical of saying, why is it necessarily the case that the only form of owning land, if you're an Afro-Colombian, is by owning collective land in that sense? So why is that link necessary? And so therefore, the question there would be whether, so while profiling and providing certain ethnicities with certain characteristics, on the one hand, is part of violence and is part of the reproduction of these structures of violence, on the other hand, I think it's important that we think of the way in which the Special Jurisdiction for Peace is framing the connection between protection of the environment and violence against Afro-Colombians as being part of the same problem because they occur in the same territory. This is part of the issue there.
Great, thank you all. I know we're almost up against 4:30, so I just wanted to maybe wrap up by just asking if there's anything else that we've missed that you all want to add before we sign off. Okay. Well, again, we really appreciate everyone attending. Thank you so much to Lisa, Charo, and Rene for your participation as panelists. And we look forward to talking about these issues going forward. Thank you so much, everyone.